Good morning. When there are multi number of accused, the defense lawyers should always try to defend the accused so that some of the accused were acquitted, and on appeal some more may be also be acquitted, and finally the appeal. The question arises here: if any defense lawyers and law students or those who are aspiring for elevation as judges must read this judgment, a fantastic judgment, deals with framing of charge at the stage of appeal without giving notice to the accused. Then difference between 148, 149 and 34, and even for sharing of common intention and a common object were discussed deeply. Very interesting case. You see, this is AR 2023, Supreme Court 5012, AR 2023, Supreme Court 5012, case from Madhya Pradesh. The sections involved Chandra Pradap Singh versus State of MP. The sections involved in these judgments were 386 Criminal Procedure Code, 216 Criminal Procedure Code, then 302, 34, 148, 149 and 201 IPC. So if you want to understand between section 34, unlawful assembly, 148, 149, sharing common object, and then question arises, screening of evidence, 201. Case is very interesting. There were near about 17 accused were tried. Three persons were done to death. Initially one was found missing, other two were searching, and at that time near a temple the accused were standing with guns and other weapons, and according to one of the accused seems to have prevented the witnesses or deceased from proceeding with. So there was obstructions. All these things are there. Finally, out of 17 accused, the lower court acquitted 3 to 8. That means 5 accused. 10, 13, 15, 17. 6, 7, 8, 9 accused were acquitted. 2, 9, 11, 12 and 16 were convicted. At the time of appeal, the High Court found that there 149 may not be, 148 may not be applicable because after acquitting the accused, some of them, the 5 persons for unlawful assembly was not there. Therefore, the High Court altered the charge under section 2164 of CRPC. Then 302 read with 34 and convicted. A2 also, A2 is appellant before the Supreme Court. Supreme Court has categorically held that the evidences of the prosecution is not sufficient to hold that this appellant, second accused, shared common intention with the main accused who called assaulted. So far as the 2 other murders are at different places are concerned, lower court acquitted the charges. So then question arises, 201, the body was dragged and thrown in the well. For that A2 was convicted for 5 years and he was acquitted from 302 read with 34 IPC. So this is the case, a very interesting case. Pages are very few, but discussions are very high profile discussion. with referring so many judgments. Therefore, if you want to understand, first of all, you read the index itself. You can understand the provisions when multi number of accused are being tried. What all are the provisions may be included? 34, 141, 147, 140 to 140. These things unlawful assembly. Then question of sharing common intention, 34 IPC. Then arises question of 201, causing disappearance of the evidence, and whether the court, High Court, on appeal, whether frame charge without giving an opportunity for the accused being heard. Go through the judgment. Best wishes.